Welcome to today's program, USPTO Hour, Supplemental Guidance on Design Applications and Recent Patents Examination Policy Initiatives. I am Sean Hunter, the Director of the Office of Patents Stakeholder Experience here at the United States Patent and Trademark Office. Before we get started today, just a few housekeeping reminders. If for any reason you should get disconnected, you can log out and then log back into today's program at any time by using the WebEx link provided and login information that brought you here. Additionally, if you are having issues with audio or audio connectivity, you can send a message directly to our digital media services team in the WebEx by selecting any panelist that has the letters D, M, S in their name and sending a message directly to them. As a reminder, we will have a live Q&A segment during today's event following the presentation. Questions were taken in advance via email at usptohour@uspto.gov. Feel free to use this email during today's event to submit additional questions as well. Again, that email address is usptohour@uspto.gov. If you have any additional questions for today's iteration or any upcoming iterations of this event series. If you happen to miss a portion of today's program, don't worry. In a few weeks, we'll be posting the recorded presentation online. The USPTO recently unveiled 7 patents business unit priorities, which are represented by the acronym INVENTS. Each priority represents the agency's commitment to strengthen the U.S. patent system, enable innovators to secure patent protection for their inventions, and provide durable patent rights that make the United States intellectual property system the best in the world. With that, it is my pleasure to introduce Charles Kim, Deputy Commissioner for Patents, Parika Solanki, Senior Advisor, Office of Patent Legal Administration, and Shannon Morgan, Supervisory Patent Examiner, Technology Center, 2900. Charles Kim serves as a Deputy Commissioner for Patents of the United States Patent and Trademark Office. As Deputy Commissioner for Patents, Mr. Kim is an authority on patent laws, rules, and examining practice and procedure, and provides executive leadership to the Office of Petitions, the Office of Patent Legal Administration, the Office of Patent Quality Assurance, the Central Reexamination Unit, and the Manual of Patent Examining Procedure staff. Prior to becoming Deputy Commissioner, Mr. Kim served as Acting Assistant Commissioner for Patents, and prior to that, held the position of Director of the Office of Petitions. He has also served as Senior Advisor to the Deputy Commissioner for Patent Examiner Policy and as a Supervisory Patent Examiner in Technology Center 2100. In addition, Mr. Kim has led the USPTO's Artificial Intelligence and Emerging Technologies Working Group. In this capacity, Mr. Kim provided executive leadership to a cross-cutting team of AI specialists from across the agency that develops and implements various AI and intellectual property policy initiatives here at the USPTO. Mr. Kim earned his Bachelor of Science in Electrical Engineering with high honors from Rutgers University and his Juris Doctor from George Washington University Law School. Mr. Kim also holds an Executive Certificate in Public Policy from the Harvard Kennedy School. Parika Solanki is a Senior Advisor with the Office of Patent Legal Administration, where she advises internal and external stakeholders on all aspects of patent legal policy with particular expertise in design patents, artificial intelligence, prioritized examination, restriction practice, and patent-related considerations in technology transfer. She has previously served as a senior advisor to the USPTO's Undersecretary for Interagency Collaboration and Technology Transfer, as an intellectual property advisor to the National Oceanic and Atmospheric Administration, or NOAA, as a review specialist in the Office of Patent Quality Assurance, and as a patent examiner in the medical diagnostics area. Prior to joining the federal government, she worked in pre-market clinical research in the medical device industry. Parika has a bachelor's degree in biomedical engineering and a master's degree in electrical engineering, both from Boston University. Shannon Morgan is a supervisory design patent examiner in Technology Center, or TC 2900 at the USPTO, where she leads examiner training and provides supervisory oversight while assisting with design practice quality initiatives. With nearly 14 years here at the office, Shannon previously served as a senior advisor to the Deputy Commissioner for Design Patents and has nearly 7 years experience as a supervisor. Before becoming a supervisory patent professional, she examined a broad range of design art areas, including D14, which is GUIs and icons, D7, which is container and consumer goods, D2, which is clothing, D24, which is medical, as well as other design arts. Prior to federal service, Shannon worked in interior decorating of residential homes. Shannon earned a Bachelor of Arts and a Bachelor of Architecture from the University of North Carolina at Charlotte and remains passionate about architectural, interior, mixed media, and graphic design. She practices art in her spare time and is a proud mom to identical twin girls. With that, it is my absolute pleasure to turn things over to Charles, Parika, and Shannon.
Great. Thank you so much, Sean. Always great to see you here at USPTO Hour. And hello, everyone. As Sean mentioned, my name is Charles Kim, and I serve as the Deputy Commissioner for Patents here at the USPTO. And I'm joined by Parika Solanki and Shannon Morgan. So Parika, Shannon, and I will discuss the focus of today's discussion will be on the supplemental guidance for design patent applications. However, we'll also provide a high-level overview of some of our recent patents initiatives. So this slide shows the agenda for today's discussion. I'll kick things off and give, again, a high-level overview of some of our recent patents initiatives, including an update on our ASAP program, our recently launched peer pilot program, as well as some recent changes to our ex-parte reexamination process. Then I'll give a high-level overview of the recent supplemental guidance that we issued for design patent applications. And I'll turn it over to Parika, who will discuss the supplemental guidance in more detail. And then we'll have Shannon go over some of the examples from the guidance that applies the supplemental guidance to specific fact patterns. And I believe we should have a few minutes at the end for Q&As. Next slide. So as I mentioned, I'll discuss some recent patents initiatives. Before we get into the specific initiatives, I did want to share a little bit of insight into the agency's thinking as we developed and implemented these initiatives. Next slide. So first, I wanted to just briefly discuss this notion that issuing timely and high-quality patents continues to be a shared responsibility between the USPTO and the patent community. And this responsibility includes, for example, ensuring that the applications that come in the door to PTO are of high quality, as the quality of the patents that we issue, the quality of the patents that go out the door, right, the PTO, are directly impacted by the quality of the applications that come in our doors. And to that end, one of the things that we're trying to do, at least with respect to the ASAP pilot and the peer program, is to try to share and leverage information that may be pertinent to patentability earlier in the process with our applicants to try to help our applicants make a more informed decision on their next steps. And that can include, for example, if there's a really strong prior art reference that's made available, they may want to consider possibly amending their applications, amending their claims in their applications. Applicants may want to delay examination, for example, to further evaluate the commercial viability of their invention, or based on this additional information, applicants may no longer be interested in pursuing their application, and they may, in those situations, they may want to abandon their application. So these are some of the things that we're thinking of as we're, again, as we're developing and implementing these initiatives. Going back to this shared responsibility, sharing these responsibilities, in our view, will help to increase the quality of the patents that we issue, And it'll also help to increase the efficiency of the examination process so that, again, we can issue patents in a timely manner. And we can also issue patents that are born strong. We are planning to continue this discussion on this idea of this shared responsibility in the coming weeks as we launch new initiatives, because we are working on new initiatives and new pilots, and you'll hear more about them soon. As we launch these new initiatives, we will continue this discussion about the shared responsibility. Next slide. All right, so the first two initiatives that I will discuss are the ASAP updates to the ASAP pilot, as well as the recently launched peer pilot. I'll start with ASAP. So this is a pilot that launched in October of 2025. Applicants that requested to participate in this pilot and those applications that were accepted into the pilot would receive a pre-examination search report from the USPTO. And this search report includes the 10 most relevant references that were identified by the USPTO's AI search tool. Once this report is issued to the applicant, there is no requirement for the applicant to respond. However, the applicant has the option to amend their claims in view of the references that are in the report. They may file a petition to defer examination. There is a fee associated with that. Again, if there's a need to delay examination, they can file that request, or they can abandon their application if they believe that that there is no longer a need to move forward with that application in view of the references that were identified. For this program, if the applicant chooses to abandon the application, they may be able to recoup some of the fees that were paid for that application. So when we first launched the program, we did require a fee that's associated with the petition, and we also capped the number of applications at 200 applications per TC for a total of 1,600 applications. Just recently, last month, we did make two changes to the pilot. The first change is we waived the fee, so there is no longer a fee to request to participate in the ASAP pilot. We also increased the cap from 200 to 400 applications per TC for a total of 3,200 applications. The pilot is currently scheduled to end on April 20th, which is, I think, next Monday. However, we are planning to extend the pilot program. So an announcement, a notice announcing the extension of the program will be issued in the coming days. Now moving on to the next initiative, which is the peer pilot, and peer stands for PCT informed examination request. And this is a pilot that was announced last week on April 8th, and it applies to national stage or 371 applications. And 371 applications are those applications that have entered the national phase of the Patent Cooperation Treaty, or PCT. 371 applications are filed after the international or PCT application is filed. And during the international phase or the PCT application process, there are certain work products that are generated, including the international search report, as well as the written opinion of the International Searching Authority. For this program, the USPTO will select certain 371 applications. And for those selected applications, we are planning to issue a requirement for information under Rule 1.105, referencing the applicable international phase work products that I just mentioned, the International Search Report and the written opinion. In response to the requirement for information, applicants will be required to respond with one of three options. The first option is to proceed with examination, and the applicant will have the ability to file a preliminary amendment. The second option is to delay examination for 12 months, and the request to delay examination will not require a fee, so there's no fee associated with that. And then the third option is to expressly abandon the application. I will mention that unlike the ASAP program, if the applicant abandons the application in the ASAP program, they will be able to recoup some of the fees. If an application in the peer pilot is abandoned, those fees will not be cannot be recouped. So we are planning to issue the requirement for information in the selected 371 applications in the coming weeks. Next slide. All right, so the third initiative relates to some changes that we made to our ex-parte reexamination process. But before I discuss those changes, again, just wanted to give a little bit of insight. So the agency views post-grant proceedings, such as ex-parte reexamination, to involve the balancing of interests. There's various interests that we are trying to balance, including trying to address potential errors that may have been made by the PTO as asserted by a petitioner or a requester, and balancing that with other interests, including the need for certainty of rights for the patents that we issue at the PTO. And in the context of ex parte reexaminations, our view is that allowing patent owners to be able to provide input prior to the order of ex parte reexamination will help to promote efficiency by helping the PTO and make a more informed decision on a determination of whether a substantial new question of patentability was raised in the request. Next slide. All right, so with regards to the change to our ex parte reexamination process, this is a change that was announced on the 1st of April, and the change allows for the patent owner to file a paper prior to a reexamination being ordered. So we call it a pre-order paper, and this paper can be filed by the patent owner without filing a petition or paying a fee, as long as it meets certain requirements. Those requirements include a page limit of 30 pages. The paper should also be limited to arguments or facts to support the patent owner's position that despite the teachings that are argued in the request, that the office should maintain the decision of patentability that was made during examination. The paper should not address matters that are not raised in the request for reexamination, and it should also not address why the PTO should exercise discretion under 35 USC 325D to deny the request. If such a third patent owner paper is filed, the third party requester generally will not be able to file a responsive paper. However, in limited circumstances, for example, to address alleged misrepresentations by the patent owner, the third-party requester may be able to file a responsive paper that's accompanied by a grantable petition under 37 CFR 1.182. The agency's view is that allowing patent owners to file a pre-order paper will help to ensure that the office is better informed with regards to the teachings that are argued in the request for reexamination, and it'll also help us to more effectively make a determination on whether a substantial new question of patentability is raised in the request. I'll just kind of pause there to give a quick plug. If for those that may be interested in learning more about the ex parte reexamination process, Sean and we did a USPTO Hour back in February that discusses reexaminations and all the great work that's being done by our central reexamination unit to address the increase in reexam requests that we received in the past few months. All right, so moving on now to the supplemental guidance on design patent applications. This guidance was issued on March 13th of this year. Next slide. And before I discuss the guidance itself, I did want to give a little bit of background, and I'll start with the statute. So on this slide, you'll see 35 USC 171. I'll draw your attention to the bolded text, which is 171A. So 35 USC 171A for design patents is the analog to 35 USC 101 for utility patents. And both statutes relate to patent subject matter eligibility. So within the bolded text that you see on this slide, the specific language relating to an ornamental design for an article of manufacture, that's the language that we will be discussing further as we go over our supplemental guidance. So we will be discussing that language in more detail. Next slide. All right, so this slide shows some of our relevant regulations. Rule 1.152 relates to the requirement for drawings in a design patent application. Rule 1.153 relates to the requirements for the specification of a design patent application. Next slide. All right, so next I'll discuss some relevant case law. Obviously, we don't have time to discuss all of the case law related to 171, but I'll just highlight a few. So historically, the courts have found that a picture standing alone or a picture per se is not eligible under 35 USC 171, and that's reflected in the MPEP 1504.01. It's also was something that was mentioned by the CCPA in Ray Schnell. The CCPA is, as you may know, the predecessor to the CAFC, Court of Appeals for the Federal Circuit. And there have been subsequent decisions that have been issued by the courts. The PTO, we have also issued a decision in ex parte Stryland. We explained that the factor that distinguishes eligible designs from a mere picture or ornamentation is the embodiment of the design in an article of manufacture. And again, that's reflected in the MPEP. I'll also just briefly mention, it's not listed on the slide here, but the Supreme Court has recognized that, that the article of manufacture as used in 35 USC 171 is broad. Essentially, the court has said that it is simply a thing made by hand or machine. Next, I'll discuss the past guidance that we issued. We did issue guidance in 2023, and I'll discuss this guidance just to provide a little bit more context and some background with regards to the process that led us to our current supplemental guidance. So on November 17th, 2023, the USPTO published supplemental guidance on the eligibility of computer-generated electronic images under 35 USC 171. This 2023 guidance was issued in response to comments that we received, and those comments were responsive to a request for information, or RFI, that we issued back in December of 2020. And in that RFI, we sought input from our stakeholders on whether the USPTO's interpretation of article of manufacture in 171 should be revised to protect digital designs that encompass new and emerging technologies. And in response to the feedback that we received from that RFI, that we determined that it would be helpful to provide further clarity and updates to MPEP 1504.01A, which relates to computer-generated electronic images. I will note, however, that the 2023 supplemental guidance did not provide guidance concerning designs that involve projections, holograms, and virtual and augmented reality, or PHVAR. And in response to the 2023 guidance, we did receive comments that we should provide additional guidance for designs involving PHVAR because computer-generated images have advanced beyond the traditional computer display screens or monitors. We also received comments that we should not require the drawings in a design patent application to depict the article of manufacture, the panel, typically it's the display panel, in solid or broken lines to comply with 171 when the design is directed to a computer icon or a graphical user interface or a GUI. Subsequently to receiving those comments, we have received continued feedback from our stakeholders that our current 171 guidance we should consider updating it to better align with other IP offices in view of advances in technology. Next slide. All right, so that leads us to the recent supplemental guidance that was issued on March 12th, 2026. We issued our supplemental guidance for design patent applications related to computer-generated interfaces and icons. This supplemental guidance provides applicants with additional flexibility with regards to the drawings, the claims, and the title, as well as highlights additional types of designs that may be eligible. Specifically, the guidance removes the requirement that the drawings depict the article of manufacture, typically in solid or broken lines, where the title and the claim properly identify an article of manufacture. So previously we required that the display, typically the display screen, be depicted in the drawings. But one of the changes that we made was that requirement that is no longer required, that the article of manufacture, again, for computer-generated interfaces and icons are no longer required. The supplemental guidance also clarifies that a design of a computer-generated interface or icon or a computer display or computer system that is for an article of manufacture is more than a mere transient or disembodied picture or three-dimensional image. The supplemental guidance also provides applicants with additional flexibilities in being able to choose claim and title language that indicates an icon or interface, again, for a computer system or computer display panel. And including these terms, one of the changes that we made was that if you include these terms, it adequately describes the design for an article of manufacture under 35 USC 171. The last change that I'll just mention from the supplemental guidance is that it highlights additional types of patent eligible designs in light of new design formats resulting from advances to technology. And I mentioned some of these designs before, and they include projections and holograms, as well as designs in virtual and augmented reality. And again, this is based on our recognition that designs of computer-generated interfaces and icons now can exist beyond the traditional display panel or screen. So I'll conclude my remarks by just briefly mentioning that this most recent supplemental guidance is responsive to the feedback that we received from our stakeholders, and it also aligns with the director's view that the doors of the USPTO are open to transformative and emerging technologies. So with that, I'll turn it over to Parika, who can discuss the guidance in more detail.
Thank you so much, Charles. Sean, if I could have the next slide, please. Okay, so before I get into some more details about those 4 key items in the guidance, I just want to take a couple minutes to define some terms here. It's important that we all have the same understanding of what these words mean so that you have the important context for the guidance that follows. So wherever we use the term icon, we're referring to a computer icon, which is a visual symbol or image that represents a computer program, file, application, or function that allows a user to quickly access and interact with various items on their computer display. When we use the term interface, we are referring to a computer interface in the space where interactions between users and computers, computer displays, and computer systems occur, and this encompasses the visual and interactive elements that users engage with, such as pages, screens, buttons, forms, and other visual components. And then finally, when we use the term transient, this means that the design is not a visual characteristic of the article of manufacture itself. Next slide, please. Okay, so let's start with the some of the guidance content regarding the drawing requirements. As Charles mentioned, if the article of manufacture is properly identified in both the title and the claim, but not shown in the drawings, for example, using broken lines, as was mentioned in the 2023 guidance, the claim will now be considered compliant with the article of manufacture requirement of 35 USC 171, as long as the design is properly disclosed and claimed in accordance with the pertinent rules and statutory requirements. Applicants can certainly continue to use the broken and solid lines, for example, to depict the portion of the display or the display screen, but for computer-generated interfaces and icons, this is no longer required practice. I would like to highlight that there is no change in this type of practice for other types of surface ornamentation. The guidance really is focused on computer-generated interfaces and icons. And then something else to consider, which I'll bring up a few more times over the next few slides, is that it is important that when using any of this guidance to make decisions about drafting your patent application, it is important to remain mindful of all the other requirements, such as 35 USC 102, 103, and 112 when drafting your drawings and your claim language and your titles. So for example, in light of the supplemental guidance, applicants are still required to comply with the clarity and enablement requirements, and they must still provide a sufficient number of views to constitute a complete disclosure of the appearance of the design, to the extent that a skilled artisan would be on reasonable notice as to the needs and bounds of that design. Next slide, please. Okay, so when a design, claim, and title are for a computer-generated interface or icon for an article of manufacture, so for example, for a computer display screen, a computer system, or a computer, we will consider the terms icon, computer icon, interface, computer interface, graphical user interface, projected interface, virtual reality interface, or augmented reality interface when they appear in the title and the claim, to be indicating that the image is not merely a displayed transient or disembodied picture or three-dimensional image, because the interface or icon is for a computer display screen, a computer system, or a computer. So to put that another way, a claim and title directed to these kinds of terms, for example, computer with a projected interface, will be treated as adequately describing a design for an article of manufacture under 35 USC 171. So all of this relates back to the definitions of those key terms that we just talked about a few minutes ago. Next slide, please. And so to give everybody a few more examples of claim language and titles that will be considered adequately describing the article of manufacture, we have computer screen with an icon, display panel with GUI, display screen or portion thereof with icon, portion of a computer screen with an icon, portion of a display panel with an icon, portion of a monitor displayed with an icon, icon for display screen, GUI for display panel, projected interface for a computer, virtual reality interface for a computer, augmented reality interface for a computer, and computer icon. So again, those are all examples of claim language and titles that will be held as adequately describing an article of manufacture under 35 USC 171 according to this guidance. Next slide, please. If it is determined that the claim language and title do not adequately describe an article of manufacture, the claim and title will be objected to under 37 CFR 1.153A or 37 CFR 1.1067A, which is our corollary for A applications, because they fail to designate a particular article of manufacture, and this objection will be maintained until the title and claim language are appropriately amended. So title and claim language practice will continue as usual, as we've outlined in the Manual of Patent Examining Procedures, Chapter 707.07E. If the drawing does not adequately depict an article of manufacture in this situation, where the title and claim also don't describe it, the claim will be rejected under 35 USC 171. And this one's particularly important because if the application is filed doesn't have written description support for an article of manufacture, this flaw will basically be fatal because trying to add the language or broken lines or anything like that after the fact will constitute new matter, which is prohibited by 35 USC 132 and 37 CFR 1.121F. Next slide, please. So another key portion of this guidance is, as Charles mentioned, is that when claim and title language indicate that an icon or interface is for a computer system, or computer display panel, this will be considered as adequately describing a design for an article of manufacture under 35 USC 171. So what that means is examiners will no longer be objecting to these types of claims and titles under 37 CFR 1.153 or 37 CFR 1.1067. So again, to give you some examples of claim language that will not be objected to under these rules for failing to identify an article of manufacture, we have icon for display screen, GUI for display panel, projected interface for a computer, virtual reality interface for a computer, augmented reality interface for a computer, and computer icon. So again, these are all examples of language that will not be objected to under 37 CFR 1.153 according to the supplemental guidance. Next slide, please. And then finally, the fourth key section of the guidance addresses additional types of patent eligible designs. So we have identified additional types of designs that are eligible for patenting under 35 USC 171 that may provide design patent protection for computer-generated interfaces and icons when the appearance of the interface or icon is separate from the computer display, or computer system that generates it, and the interface or icon is for a computer display, or computer system, such that the interface or icon is more than a transient or disembodied picture or three-dimensional image. So to describe this another way, this covers the category of designs that include, for example, projections, holograms, PHVR, as Charles defined for us earlier, when they are interfaces or icons for the computer display, or computer system. So those are additional types of patent eligible designs under 35 USC 171, according to the guidance. Next slide, please. All right, so just to go back to what I mentioned earlier, whenever applicants choose to use some of the options explained in this guidance, it is still very important to remain mindful of all the other patentability requirements which remain unchanged, such as 35 USC 102, 103, and 112. This is important. We want to make sure that people are considering the full scope of impact of using these options when drafting their overall patent applications. So one example is that it's important for applicants to remember that they have to still comply with the clarity and enablement requirements. And it's also still important to provide enough views to constitute a complete disclosure of the appearance of the design per 37 CFR 1.152 to reasonably convey the metes and bounds of the claim design. And then one additional note here is if the drawings show various appearances across different figures of the claim design, but there is no descriptive statement explaining how those appearances relate to one another, it would be reasonable to reject that claim under 35 USC 112B as being indefinite because we can't be clear on what the intended scope of the claim as a single unitary design applied to the article of manufacture is in that situation. So those are the key highlights of the details of our supplemental guidance. And now I will hand it over to Shannon, who is with us from the TC, and she will walk us through some of the selected examples provided in the guidance so that we can see how this plays out in various scenarios.
Thanks, Parika. Okay, so now we're going to cover some selected examples from the supplemental guidance. Okay, so for this first example, we have a computer display screen with icon. The description reads, the figure is a front view of a computer display screen with icon showing the new design. Here, the broken lines are showing a portion of the computer display screen that form no part of the claim design. And the claim is for a computer display screen with icon. Next slide. So in this example one, as presented, the claim design does comply with the requirements of 35 USC 171 for the following reasons. The title, claim, and description all recite a computer display screen, which is considered to be an article of manufacture. The title, claim, and description all recite a computer display screen with icon, which indicates that the image is not merely a transient or disembodied picture or three-dimensional image, but an icon for a computer display, or computer system. Additionally, the drawings do depict the design embodied in a computer display screen in broken lines. The drawings do comply with the requirements of 37 CFR 1.152, as the drawing does contain a sufficient number of views to constitute a complete disclosure of the appearance of the design. Additionally, the title and claim do comply with the requirements of 37 CFR 1.153A or 37 CFR 1.1067A for international design applications, and that's because the title and claim do adequately designate an article of manufacture. Next slide. Okay, so for this next example, we have example 4, and it's directed to a paper stack icon for a computer display screen. Here the description reads, the figure is a front view of a paper stack icon for a computer display screen showing the new design. And the claim is directed to a paper stack icon for a computer display screen. Next slide. So as presented in this example, it does comply with the requirements of 35 USC 171 for the following reasons. The title, claim, and description all recite a computer display screen, which is an article of manufacture. The term "for" with computer display screen indicates that the claim is not for an icon per se. And the title, claim, and description all recite an icon for a computer display screen, which indicates the icon is not merely a transient or disembodied picture or three-dimensional image, but an icon for a computer display, or computer system. Additionally, in this example, the drawings do comply with 37 CFR 1.152 because there is a sufficient number of views to constitute a complete disclosure of the appearance of the design as embodied in the disclosed article. Additionally, the title and claim do comply with the formal requirements of 37 CFR 1.153A, or in international applications, the formal requirements under CFR 1.1067A, because the title and claim do adequately designate an article of manufacture. It is important to note that the scope of the claim will be limited to the overall appearance that is shown in the figures, and applicants must still comply with the enablement and clarity requirements of 35 USC 112. Next slide. So for example 5, we have a paper stack icon. The description reads, the figure is a front view of a paper stack icon showing the new design. Here the claim is for a paper stack icon. Next slide, please. So reviewing this example, the claim should be rejected under 35 USC 171. And this is because there's no article of manufacture disclosed in the application. Additionally, the title and claim should be objected to under 37 CFR 1.153A or 37 CFR 1.1067A for international design applications. And this is for failing to designate a particular article of manufacture. Next slide, please. So for example 8, we have a projected interface for a computer system. The description reads, the figure is a perspective view of a projected interface for a computer system showing the new design. And the claim is for a projected interface for a computer system. Next slide, please. So reviewing this example, Assuming that the figures do provide a complete disclosure of the appearance of the design as required by 37 CFR 1.152, the claim design does comply with 35 USC 171. And this is because the title, claim, and description all recite a computer system, which is an article of manufacture on which the design relies upon for its existence. Also, the term "for with computer system" indicates that the claim is not for a transient or disembodied image per se. And the title, claim, and description all recite an interface for a computer system, which by definition is not merely a transient or disembodied picture or three-dimensional image, but an interface for a computer display, or computer system. Additionally, in this example, the title and claim do comply with the formal requirements of 37 CFR 1.153A, or in international design applications, the formal requirements of 37 CFR 1.1067A. And this is because it adequately designates an article of manufacture. Again, it's important to note that the scope of the claim will be limited to the overall appearance shown in the figures. For example, examiners may determine that the scope of the claim may not protect the appearance of the projected interface on a curved or irregular surface. Also, a design shown and described in the manner illustrated by this example must still comply with the enablement and clarity requirements under 35 USC 112. Next slide, please. Okay, so for this next example, example 10, we have a virtual reality motorcycle interface for a computer. And figure 1 is a top-down view of a virtual reality motorcycle interface for a computer showing the new design. Figure 2 is a front view, and figure 3 is a perspective view thereof. It is important to note that in this example, there is a special description that reads, figures 1 through 3 disclose the complete three-dimensional virtual appearance of the design claimed. And the claim is for a virtual reality motorcycle interface for a computer. Next slide, please. So as presented in this example, the claim design does comply with the requirements of 35 USC 171 for the following reasons. The title, claim, and description all recite a computer, and a computer is considered an article of manufacture on which the design relies upon for its existence. Additionally, the term "for with computer" indicates that the claim is not for a transient or disembodied image per se. And the title, claim, and description all recite a virtual reality motorcycle interface for a computer, which by definition is not merely a transient or disembodied picture or three-dimensional image, but an interface for a computer display, or a computer system. Additionally, the title and claim do comply with 37 CFR 1.153A or 37 CFR 1.1067A in international design applications. And that's because the title and claim do adequately designate an article of manufacture. And this is through the reference to a computer in the title. Next slide, please. Also, it's important to note that the scope of the claim will be limited to the overall appearance shown in the figures provided. Examiners should use a professional judgment when determining whether the figures satisfy all other statutory requirements, and this includes 35 USC 112. For purposes of this example, regarding whether the design satisfies all the requirements of 35 USC 171, it is assumed that figures 1 through 3 do provide a sufficient number of views to constitute a complete disclosure of the appearance of the design as required by 37 CFR 1.152. Applicants should remain mindful to provide a sufficient number of views to constitute a complete disclosure of the appearance of the design as required by 37 CFR 1.152. It would be reasonable to reject a claim under 35 USC 112B as being indefinite if there is no descriptive statement explaining how various appearances shown across different figures relate to one another, specifically in regard to the intended scope of the claim as a single unitary design applied to the article of manufacture. Next slide, please. Okay, so for this next example, which is example 11, it is directed to a virtual reality motorcycle interface. And in the drawings, figure 1 is a top-down view of a virtual reality motorcycle interface showing the new design. Figure 2 is a front view, and figure 3 is a perspective view thereof. And the claim is directed to a virtual reality motorcycle interface. Next slide, please. So reviewing this example 11, the claim design in this example does not comply with 35 USC 171. It doesn't comply with 35 USC 171 because none of the title, claim, and description recite an article of manufacture, and the drawings do not depict an article of manufacture. Additionally, the title and claim do not comply with the formal requirements of 37 CFR 1.153A or formal requirements under 37 CFR 1.1067A for international design applications. And that's because the title and claim do not identify an article of manufacture. Next slide, please. So for this next example, it is directed to a digital motorcycle picture. The description reads, the figure is a perspective view of a digital motorcycle picture showing the new design. And the claim is for a digital motorcycle picture. Next slide, please. So in regards to this example 12, the claim design in this example does not comply with 35 USC 171. Particularly, none of the title, claim, and description recite an article of manufacture, and the drawing, when read in light of the title, claim, and description, also do not depict an article of manufacture. Additionally, the picture appears to be a transient or disembodied image. Also, the title and claim do not comply with the formal requirements of 37 CFR 1.153A or 37 CFR 1.1067A for international design applications, and that's because the title and claim do not identify an article of manufacture. Next slide, please. Okay, so these next few slides are example summary sheets that kind of give you an overview of the examples from the supplemental guidance and whether they comply with the requirements of 171, as well as the formal requirements under 1.153 or 1.1067 for international applications. And it's meant to be a quick reference, but it is important to note that you should refer to the full examples for important details regarding the full disclosure of the claim design, as well as the drawing compliance under 37 CFR 1.152, possible amendments, and other critical contexts. Next slide, please. Next slide, please. And next slide, please. Okay, so some key takeaways. The supplemental guidance includes 4 key points for designs related to computer-generated interfaces and icons. First, it removes the requirement that the drawing depict the article of manufacture in either solid or broken lines for design pattern applications that are drawn to computer-generated interfaces or icons, where both the title and claim properly identify an article of manufacture. Secondly, it clarifies that a design of a computer-generated interface or icon for a computer display, or computer system is more than a mere transient or disembodied picture or 3-dimensional image, and is patent eligible subject matter when it's disclosed and claimed in accordance with the pertinent rules and statutory requirements. Thirdly, it clarifies that the claim and title language that indicates that an icon or interface is for a computer system, or computer display panel adequately describes the design for an article of manufacture under 35 USC 171. And fourthly, it highlights additional types of patent eligible designs, and this is based on the USPTO's expanded understanding of design patent protection in light of new design formats that are the result of continued modernization of technology. And with that, I'm going to turn it back over to Sean for our Q&A portion. Thank you.
Thank you. Let me first say a huge thank you to Charles, Parika, and Shannon. We are now at the question and answer portion of today's program. As a reminder, questions were taken in advance, and if you still have questions, you can send those to USPTO Hour at uspto.gov. With that, I'll go ahead and get started with some of the questions that we did receive in advance. All right, let me see. So first question, first and foremost, regarding the peer pilot, how will 371 applications get selected for that program?
So that's a great question. Thank you, Sean. So for the peer pilot, again, this is a little different than the ASAP pilot, where applicants can request to participate in the pilot. In peer, the PTO will be selecting certain 371 applications. And these applications will be selected based on the age of the application, as well as the areas of high pendency. So specifically, we'll be looking at a targeted window of age from docketing. In other words, applications that are, for example, X months away from docketing. So that's one thing that we'll be looking at. And we'll also be looking at those applications in high pendency areas. Applications that are X months from docketing in low pendency areas will likely not get selected, but those applications that meet that criteria in those higher pendency areas will be selected for the pool of applications that we will be considering. And then within that pool, we will be selecting a subset of those applications to issue the requirement for information.
Okay, thank you for that. Let's see, what else do we have here? What is the USPTO doing to ensure consistency and reliability in the implementation of this guidance by examiners?
Shannon, did you want to take that one?
Yes. So we have trained our design examiners on the details of the guidance to ensure consistent application of the guidance. And we continue to have a dialogue with our examiners as they begin to handle applications that take advantage of the options in this guidance. So it is also important to note that the training has been posted publicly so that our stakeholders also understand how examiners are applying this guidance. And the supplemental guidance will also be added to the MPEP in due course.
So I believe that training, on our supplemental guidance, the training material has been posted on our webpage.
Okay.
And Shannon, I believe pretty much most of the examiners in Technology Center 2900 have been trained on the supplemental guidance. Is that correct?
Yes, that's correct.
Okay.
Thank you.
Thank you both for that. Is the USPTO accepting public comments?
I can take that one. Yes, we are accepting public comments on the Federal Register notice where the guidance was published. The comment period is open until May 12th, 2026. And if anybody wants to submit comments, we certainly invite your input. It's an important complement to the examiner dialogue that Shannon just highlighted. You can just go to federalregister.gov and pull up the supplemental guidance notice there. And then in the left sidebar, you'll see a stack of icons, and there should be one that says public comment with a bubble, and that'll take you to regulations.gov to submit the comment there.
Perfect. So for those of you that are still interested in submitting comments, you still have time to do that. So please take advantage of that opportunity. Let's see, what else do we have for you? You mentioned another pilot program earlier, ASAP. Can a request to participate in ASAP be filed after an application has already been filed?
So I can take that one. So for the ASAP program at this time, in order to request to participate in that program, it must be filed at the date of filing the application. So to answer your question, no, it cannot be filed after an application has already been filed. I do want to briefly mention that there are other requirements that also must be met, including filing the application electronically and ensuring that the specification, the claims, and the abstract conform to the PTO's DocX requirements.
Okay. Thank you for that. Let's see what else do we have here. I know we're a little tight on time. I'm going to try to sneak a few more questions in here. How do examiners handle applications that are mid-prosecution when prior to the issuance of the supplemental guidance, the examiner previously rejected the claims under 35 USC 171?
Sure, I can take this one.
Okay.
So when the application is next due for an examiner action, the examiner will analyze the claim under 171 in light of the supplemental guidance. If the examiner does determine that the claim is now eligible, the previous 171 rejection should be withdrawn. Additionally, if the examiner determines that the claim remains ineligible under the supplemental guidance, the rejection can be made final if the basic thrust of the rejection under 171 and the present office action remains the same from a previous office action issued before the supplemental guidance. However, if the basic thrust of the 171 rejection is changed in the next rejection, that rejection should not be made final.
Okay. All right. That's helpful. Thank you for that, Shannon. Along these lines, and I'm trying to be mindful of time here, does this mean that all projections and holograms are now patent eligible designs?
I can take that one. So in short, no. And this calls back to the background of in re Schnell and ex parte Dryland. We're still aligned with both of those. So in order for a projection or hologram to be patent eligible, it must be a computer generated interface or icon for a computer system or computer display, because the hologram needs to be more than a transient or disembodied picture or three-dimensional image.
Okay. Thank you for that. Let's see. Does the supplemental guidance change examination under any other statutes?
It does not, so I'm gonna take that one too. So just, I think I mentioned it a couple of times in the presentation, but it bears
Sure.
repeating, is that it's important to consider all the other longstanding requirements that are not changed when choosing whether or not the options in this guidance are the right choice.
Okay. This question, it says, why is the USPTO revising the 2023 supplemental guidance um, for examination of design patent applications? Excuse me, related to computer-generated electronic images, which includes computer-generated icons as well as GUIs.
Yes, I can take that one, Sean. So
Sure.
as I mentioned, kind of in the background, we have been actively engaging with stakeholders on these issues going back to at least December of 2020. And we've issued previous guidance since then. We've issued a request for information. We've received comments. We continue to receive feedback from our stakeholders. So it's partly based on the robust engagement that we have been having with our stakeholders over the past few years. Also, there is a recognition that technology has advanced so that these digital designs are not necessarily limited to kind of traditional display panels. And lastly, as I mentioned earlier, these changes allow us to be aligned with the view of Director Squires that, again, the doors to the USPTO are open to emerging and transformative technologies.
Okay, thank you for that. Let's see, this one is a little bit longer. I'm watching the clock here. It says, I plan to file a patent application that is directed to the configuration of shape of a three-dimensional article with surface treatment or surface ornamentation. Does this new supplemental guidance remove the requirement that the drawings depict the article of manufacture?
So I'll keep the answer short, and that's no. So the supplemental guidance really is focused on computer generated interfaces and icons. For all other types of surface ornamentation, it's practice as usual, the way we've outlined it in NPEP 1503.02, subsection 4.
Okay, I see we're just about 5 minutes over time here. I will use this last one. It's a two-part question. Are broken lines permitted in virtual reality design patents? How do examiners examine virtual reality design applications? Sort of two parts of the same question.
Rika, did you want to take that one?
Sure. So this sounds like we have, they're asking a question about part of an application, but it's really important to have the full context of the claim language, the title, the background, all of that in order to meaningfully answer that question. What I would recommend is just the supplemental guidance provides a lot of detail and explanation of this section for the PHVAR category or the types of designs. So I would just direct attention to that to use as a guidepost if that helps.
Okay, thank you for that. I'm looking at the clock here. We're at 1:05. I want to be respectful for everyone's time. So first, let me say thank you again to our panelists, to Charles, Parika, and Shannon, for taking time out of their busy schedules to join us today. Thank you all for attending. If we did not get a chance to get to your questions, we will make sure that the questions are passed along and we'll get back to you as soon as possible. For those of you who had questions about the slides will be made available soon. So please check back at the event page where you register for today's program. The slides will be available there. And also a post-event survey will be sent out to the email address that you use to register for today's program. We really would appreciate if you take the time to fill out that survey, whether that feedback is good, bad, or otherwise. We use it to improve this program and others here that we offer here at the USPTO. So with that, I hope you guys have a great rest of the day, a great rest of the week, and hopefully we'll see you somewhere soon. Thank you.